Well, welcome back, folks. We're going to get going here right away with our next presentation and speakers. Thank you again for hope you had a good lunch and a good break. So I'll ask Todd and Kate if you can turn on your cameras and mics. I'll introduce you, and then before I hand over the floor to you. There they are. Hi, guys. So I'll do a bit of an introduction. We've got two great speakers here today. Kate Gunn, who's a partner with First Peoples Law, LLP, and then Todd Bailey, who's a consultation specialist working with the Swan River First Nation up around the Slave Lake Canuso area. So Kate Gunn, again, partner at First Peoples Law. Like I said, she holds an LLM from the University of British Columbia, where her research focused on the interpretation of treaties between Indigenous peoples and the Crown. She's also a founding member of the Justice and Corporate Accountability Project, which is a legal clinic that provides advocacy and support to communities affected by transnational corporate activities and resource extraction. Todd Bailey, who I've known for quite a few years, consultation specialist, as I said, at Swan River First Nation. He holds a Bachelor of Science in Forestry from the University of New Brunswick and is an RPF in both Alberta and BC. Prior to working with Swan River First Nation, Todd spent the first 25 years of his career employed with the forest industry, specializing in areas of silviculture and planning. Todd currently sits on many local, provincial, and national committees and organizations advocating for the inclusion and protection of Indigenous peoples' rights, perspectives, and livelihood in the forest management policy, operations, and education. In his spare time, Todd can be found trail running, climbing mountains, winter hot tenting, and backcountry camping. Thanks, Todd. Thanks, Kate. Okay, I'll turn it over to you guys. Take her away there. Todd, you can start sharing your presentation.
All right, let's see. All right, everybody can see that? It's okay?
Yep, I can see it.
All right, I guess you can teach an old dog new tricks.
All right, looks good. So hi everyone. Todd and I have decided to kind of divide up the presentation today. So I'm going to start and I'm going to try to rely on Todd to flip through the slides, and then I'll turn it over to him for the second half. And yeah, to start with, just want to say I'm really happy to have the chance to speak with everyone today, if not see them. I'm a lawyer at a firm in sunny Vancouver. It's pouring rain outside. And I work solely with First Nations and Indigenous coast to coast. My practice is primarily working with First Nations to advance and implement their inherent and constitutionally protected rights. And a lot of that work right now is focused on Treaty 8 in Northern Alberta. So I'm glad to have a chance to be here today. I know it's a really important issue for everyone here. And also glad to be able to present together with Todd. So I think all will provide kind of a high-level overview of some of the legal principles and considerations around consultation, and particularly in the forestry sector. And then I'll turn it over to Todd to share some of his practical experiences as a consultation specialist with Swan River. Next slide, please. So in thinking about, in thinking about this presentation and what might be helpful, thought it'd probably be good to try to avoid as much technical and legal language, and instead zoom out and take a bit of a bigger picture approach about what consultation is, like what the underlying reason and principles are for it, and then focus in on some of the challenges and considerations that come up. So I thought I'd start by talking a little bit about Swan River Treaty 8 and the relationship and rights and responsibilities that flow from the treaty. Then a little bit about consultation as a concept and some of the recent developments in the law. And then I'll try to connect that to some of the opportunities that we see going forward to build a more positive relationship and look for beneficial outcomes for everyone. And can skip to the next slide, please. So one thing that I think is always important for these kind of presentations is just to talk a little bit briefly about the perspective that we're coming from, because I know one of the nice things about this group today is that there are lots of different orientations and backgrounds here. And so for myself, I'm a settler in Canada. I have families from Scotland, about 2 generations on one side, 7 or 8 on the other. And professionally, my training is in Canadian law, and specifically on constitutional law issues and Crown Indigenous relationship, particularly in relation to treaties. And so in that capacity, I provide advice to First Nations about the implications of Canadian law, or sometimes it's referred to as like Aboriginal law, in relation to their rights. But more and more, this work also involves working with Indigenous groups in revitalizing and implementing their own laws under the direction of leadership and members. And so that's why I think it's really important to take a look at some of those deeper issues before digging into the more specifics around consultation. And so I think one of the first parts that's important with consultation issues is the underlying context. It's easy to fall into a pattern where it feels like the treaties are sometimes talked about like historical artifacts or a thing of the past. But in Alberta, Treaty 8 was only finalized in 1899. And so that's the date that Indigenous peoples in that part of what's now Canada agreed to share lands and resources. And so for those of us who are not Indigenous, who are not Indigenous parties to Treaty 8, our ability to benefit from and live on those lands is because of that treaty. And even today, there are a lot of misconceptions about treaties. I think this is partly because for a number of decades following the conclusion of many of the treaties, it wasn't possible for First Nations to hire lawyers or defend their rights in court. And even now that it is possible, there are a lot of risks and complications involved in bringing those kind of issues before Canadian courts. And I think treaties are also often misunderstood because there are different perspectives on what was and what wasn't agreed to. And so in particular for Treaty 8, the nations understand that it was established to create a framework for relationship of reciprocity and respect. And that it's informed both by the written English version, which provides rights, including rights to hunt and fish and trap, but also includes the oral understandings and promises that were made at the time of the treaty. And that's important, not just for the Indigenous parties, but more broadly, because courts have also been clear that those additional promises and oral understandings are also part of the treaty, and they need to be taken into account when we think about how treaties are going to be fulfilled in a present day context. Another important part of treaties that don't always get discussed relates to laws and jurisdiction, who has the right to make decisions about lands. I think for a lot of non-Indigenous people in Canada, when we hear reference to laws or the rule of law, it's often easy to assume that we're talking about federal or provincial or municipal laws. But in the case, for example, of Treaty 8, the nations who entered into treaty, their understanding is that they didn't surrender their decision-making over their lands when they did that. And again, this is of course important for the Indigenous treaty parties, but it's also important because in Canada, the Supreme Court recognizes that Indigenous peoples' laws predated and survived colonization, and that they continue to exist today. And so, in effect, what it means is that in Canada, there's a plurality of laws and decision-making authority. It's not just specific rights under a treaty. And what it also means is that although those laws were suppressed for decades, that Indigenous peoples are now really working to revitalize and implement those laws. And so, while it's a complicated issue and very much a work in progress, I think one of the key takeaways is that if we're looking for ways to move forward in ways that don't replicate some of the mistakes that have been made in the past, one important way to look to do that is to try to find ways to really recognize and respect and give effect to those Indigenous laws about caring for and managing resources in their territories. Next slide, please. I'm sorry, Todd, I'm just going to see if I can make it just a little bit bigger so I can see what slide we're on. Got it. Okay. So the next piece that I wanted to touch on briefly is around how courts have addressed treaties in recent decades. I won't talk about specific decisions, but I think it's helpful to talk about some of the more recent comments that courts have been making, just to get a sense of some of the general directions and themes. This is largely because, as we talked about, the treaty relationship was intended to set out a process to manage how lands are used and shared, and it's not a static document, but it's supposed to be a living agreement. in cases of disagreement, that's often when we see that courts are asked to weigh in. So a couple of recent principles that have come up is that, firstly, particularly in Treaty 8, Canadian courts confirmed that when the Crown entered into Treaty 8, it promised to protect Indigenous treaty parties' way of life as a whole. And so I think it's important for a number of reasons, but one of them is that it means that treaty parties' promises aren't limited to just specific rights to hunt or fish in certain areas. It does include that, but that there's also this overlying or underlying promise to protect that existing way of life. And so I know I often hear from First Nations concerns about some approaches to consultation that are really focused on site-specific concerns. And while those can be important, I think one of the reasons why a lot of First Nations find that it's not sufficient to really address some concerns about particular activities on their lands is that it doesn't speak to that kind of wider issue of maintaining a way of life and ensuring the integrity of the territory as a whole. And then the second principle that I'll touch on briefly is around what's sometimes called the take-up clause. And so in the written version of Treaty 8, it refers to the Indigenous parties having a right to continue to hunt and fish and use the lands as they did prior to treaty, but subject to the provinces, or in that case, the Crown's right to take up lands for a variety of purposes like settlement and resource development. And for a period of time, the way that was interpreted was that in areas where there are treaties, governments could take up land, so put the lands to use in ways that they saw fit, as long as they've consulted with First Nations. But what courts have clarified is that even in exercising the take-up clause and even exercising that power, it can't be done in a way that's inconsistent with the Crown's treaty promises. So governments actually, they have a positive obligation to protect treaty rights, and it shifts it again away from things like site-specific impacts and more towards looking at how does a proposal or development affect an entire way of life and that underlying treaty promise. And that includes more and more things around cumulative effects and just taking into account the larger picture rather than a more kind of limited box checking approach to consultation. Next slide, please. So just briefly on kind of underlying nuts and bolts of consultation, I think we're all touched on this today that Indigenous people's rights are protected in Canada under Section 35 of the Constitution Act, and that those protections exist because Canadian courts recognize that Indigenous peoples existed prior to the arrival of Europeans and organized societies, that they lived on and cared for their lands, and that there's more to be done in order to reconcile the ongoing assertion of authority and jurisdiction by governments over Indigenous peoples and their lands. When we talk about the types of rights that are protected under Section 35, there's Aboriginal rights, which we refer to as kind of the inherent rights of like practices that originated before colonization that are continued to be carried out today, and then treaty rights, which are guaranteed under the treaties. Those can be overlapping in some cases, in some cases not. And one of the things that I think is important to remember is that because they're protected under the Constitution, it means they're entitled to the highest form of protection under Canadian law. So I think for all of us, like, thinking about not being able to exercise our constitutional rights, it feels like a really serious thing. And so when we talk about decisions or activities that affect rights in this context, one thing to remember is that those rights that we're talking about, they're of immense importance, both culturally and identity-wise for the perspective of the Indigenous treaty parties, but also legally and from a treaty relationship perspective of the government. They're also very important because there are obligations to ensure that if those rights are being infringed, that the limit is as minimal as possible, and that the rights are recognized and protected for future generations. And then another piece that I think is important to note around what attracts consultation, why consultation exists, is that governments can be required to consult about rights that might not be fully recognized or determined yet by courts or governments. So in fact, the reason for consultation first arose in the context of rights that were asserted by the Haida in BC. And the court said in that case that the reason that consultation exists is to help protect those as yet undetermined rights. So that, say, a right relation to, in that case, it was particular cedar trees, wasn't completely eroded by the time they were recognized. And so consultation now, it applies both to rights, for example, under treaty where there's general agreement about what they mean, but also rights that maybe more needs to be discussed about. And there's a kind of spectrum of what the obligations look like, depending on whether it's a right that's recognized or not. But I think it's just important to keep in mind that it's not necessarily limited to just rights that appear in the written treaty document. Next slide, please. Thanks. So just turning down to some of the more kind of specific principles around consultation. As I said, like it does vary depending on the nature of the impact. So, how much is an activity going to affect a particular right? What type of right is at stake? What type of activity? But broadly, I think the principles that are helpful to keep in mind are that consultation needs to take place on a flexible, iterative basis. So it's not a matter of kind of coming to a First Nation and saying, here's the approach that we're going to use, and please follow it, and these are the deadlines, and proceeding on that basis. It's really intended to be something that's developed and implemented in partnership. And in that vein, that governments, or if it's a company that's carrying out aspects of consultation for a government, it's more than just listening to or hearing the perspective of the First Nation, but more really seeking to understand and trying to address those concerns through steps to minimize or avoid or mitigate adverse impacts. And part of that, of course, includes being prepared to make changes. So it's not consistent with the principles established for consultation to sort of have a set proposal. And I think that also goes to one of the points that's been raised by earlier presenters about really the importance of engaging as early as possible when there's still room to make those changes. Next slide, please. So just a couple of other brief comments on principles underlying consultation. One is around that the First Nations have a right to be consulted through representatives of their choice. And I think one thing that we maybe don't always realize is that the treaty rights are collective in nature. So individual people can exercise treaty rights, but as a whole, they're held by that rights-bearing community, the descendants of the people who entered into treaty. And so today, First Nations have the right to choose how they're organized, who speaks for them in a given context. And so it's important, I think, for whether governments or companies, when they're engaging, to be mindful of that and to really be flexible and respectful about how a First Nation or an Indigenous organization wants to be engaged with. Secondly, the consultation needs to include the possibility of accommodation. And I think that really goes back to the comment I made earlier about needing to be prepared to make changes to a decision. And I know we've also talked a little, or there's been talk earlier about just the concept of consent versus veto. And at least like what I see in different parts of the country is that there's been a real movement away from consultation as being sort of the end game for both governments and First Nations and companies, that there's a need for a more robust and meaningful type of engagement that really is based more on a partnership consent-based model and less about going through a list and satisfying certain requirements. And so the quote below about consultation not being just an opportunity for First Nation to blow off steam kind of speaks to that as well, I think, in that what I'm seeing more and more in different contexts across the country is that successful consultation usually involves collaboration that starts from the outset, where there's the opportunity for a First Nation to really work in partnership with both the government or company to develop a process that works for them, including things like sufficient capacity funding to be able to properly understand the impacts and time to engage with their community. And ultimately, really an opportunity for the community to be able to say yes or no. And keeping in mind that in most circumstances, there will be a way to get to yes, most but not always. And that getting to that consent, there's many creative ways to get there. But that without a meaningful opportunity for a community to, at the end of the day, say, this particular approach is not working for us, it really is hard to envision an approach to consultation that is meaningful under that. So I think that's one of the reasons it's really pushing towards a more consent-based approach overall to consultation. Next slide, please. So one piece I think really struck me when I was listening to some of the earlier presentations, and that I noticed is maybe perhaps more of a focus in Alberta than some jurisdictions, is around the concept of delegation. And so by delegation, I mean the concept of governments relying on proponents to carry out aspects of consultation. Courts have certainly said that there's room for governments to do that, like especially to delegate procedural aspects of consultation to companies. And I think often, depending on the community, there's good reasons, both from like a relationship building perspective and then also from just a logistical perspective, why engagement with companies as a kind of first stop is desirable. Not always, but frequently. But there's also, I think, important to keep in mind that even when companies are carrying out those delegated aspects of consultation, what a company can't do is ultimately fulfill the duty to consult. That obligation is always going to rest with the Crown. So even if a company can go through a whole kind of checkbox of requirements that might be set out under government policy, at the end of the day, if the Crown, if in this case, say the Alberta government, the government that's making the decision, hasn't discharged the duty to consult in accordance with the principles that courts have set out, then there's that risk that permits can be quashed or suspended. And I think more importantly, that decisions can be made where a community's rights haven't been considered or addressed properly. And so I think this point both speaks to the importance for companies of really building those positive relationships with communities, but also knowing that there may be times when, for example, a particular type of mitigation or accommodation isn't something that a company can do. Maybe it's not something the company wants to do. And that where that, if and when that breaks down, that ultimately that responsibility for upholding the treaty relationship and fulfilling the consultation, it does go to the Crown first. Next slide, please. So really briefly, I think, actually Todd might speak about this in a little bit more detail, but I thought I'll just really quickly go through some of the common challenges that come up for First Nations in Alberta, but right across the country as well, when faced with consultation. And I think capacity funding is a huge one. Just being able to participate in a meaningful way is incredibly difficult for communities. Often they're faced with significant volumes of referrals, not a lot of staff, and real responsibilities both to the community and also to protect lands for now and into the future. And so a lot of responses and concerns around things like timing and funding, I think, really speak to gaps in the way consultation is sometimes done. Another one of the challenges that I think a lot of folks are really starting to grapple with more is around cumulative impacts and just how we can think about engaging with communities in a meaningful way, which necessarily needs to take into account the cumulative impacts of previous and ongoing activities in the territory. And so as we face more struggles around climate change, and as more and more lands do get put to use, I think this becomes an increasingly more important piece of the conversation. For a long time, at least in the kind of legal realm, consultation was viewed as much more, I wouldn't say piecemeal, but more specific to a particular referral. And I think there's a growing acknowledgement now that there's a much larger context, and that without that context, it's pretty hard to engage and make decisions in a meaningful way. And my last point there, just on inadequacies in the engagement process generally, probably just speaks to most of the things we've spoken about here already. Lack of funding, volume, focus on maybe a particular inflexible approach to consultation. And that's not to say that every company does that they don't by any means, but that where challenges arise, that those are some of the reasons that often come up. Next slide, please. And so this is my last slide, and I just thought briefly before I turned over to Todd, having touched on some of the historical concerns, and now some of the present day concerns around climate change and projects not moving ahead and all of these things, to maybe shift briefly and just, I think although there's a kind of heaviness about some of that, that we are also at a point where I think there's a lot of really important opportunity. I think like the public at large is becoming a lot more cognizant of our shared current context of colonization in Canada, especially around things like residential schools. There's a real move towards the revitalization of Indigenous laws and governance and renewal of the treaty relationship, and affirmation in court cases and in things like the UN Declaration about the importance of consent-based decision-making, and that inherent in these developments is an opportunity to rebuild and renew the relationship that Canada is based on in a way that is a lot more positive and meaningful than it has been so far. And so one of the ways that I know that Todd and I have talked about is just the fact that for companies, there might be creative ways that go beyond following a policy and checking a box, that really do go to approaching a community and asking what they need in order to get to consent, knowing that consent might not always be possible, but that if you're open to it, that working with the community to get towards or to get closer to consent is a way both to promote certainty for a particular project, but also a way to really create long-term certainty for both First Nations and for everyone else by strengthening that underlying treaty relationship and really returning to the principles that the treaty was intended to promote in the first place, which is about sharing the land, managing it in a respectful way, and making sure that it is intact and still able to be used and for folks to benefit from it, both now and into the future. So I think with that, I'll turn it over to Todd, and then I'll be here if there's further questions at the end. Thanks, everyone.
All right. Yeah, thanks, Kate. Just want to start off by thanking Hudson for the opportunity in CIF today, for sure. I think it's timely. It's a great opportunity here today, so we can provide some information and start and continue the dialogue. And there's some positive things for sure happening on the landscape, and that's on the land, like physically, and also through, I think, some case law and policy and just the relationships that nations are starting to have. Some build, they're at different stages, I guess, but I think things are starting to improve a little bit. I just, again, was a little bit reluctant to do this, only because I didn't really want the message to be really a feel-good thing where people walk away and pat themselves on the back about all this great and wonderful work that's being done. And certainly there is in some cases, but there's a heck of a long ways to go from the First Nations perspective anyways. And actually, and just for a disclaimer, I guess, is, I'm not speaking for First Nations, Indigenous peoples, right? As a forester and the consultation department with Swan River First Nation. So I'll speak on some of those challenges of working with government bodies and industry or industry proponents. Some of the challenges, and then some of the, the solutions or some of those things that we've worked through. But I want to thank the previous speakers for sure. They it's nice that I think they put the folks who can speak best up front, and then I think I'm at the back of the bus. So hopefully, folks, and it's after lunch, so you don't start to fall asleep. And it's difficult now because you can't see. I don't know if I'm getting like a round of applause, or you can't tell on this virtual stuff. And actually, step back, this is like maybe my fourth video, because I held out the whole pandemic and just bought a camera like a couple months ago. So you'll have to bear with me. So
and by the way, I'm the last. I'm in the very back of the bus. So.
Okay, good. So yeah, I just so thanks for everyone else. Thanks for the opportunity. I think prior to starting here, I put in the chat a recommendation if people are interested in a book called Clearing the Plains. I think it's very informative. It's enlightening. It gives a, I think it's it should be a required reading, I think. So I would highly recommend it. It's called Clearing the Plains. I'm reading actually, and on a bit of a lighter note, I'm reading another book about anti-gravity. I just can't put it down. Okay. So yeah. Anyway, so I think, and then before I kind of get into a little bit more detail here, I just wanted to comment a bit on and appreciate Minister Wilson's comments to start off the conference today, and the references to building a house. And I think from the First Nations, many folks would say the house was already built. The house was built and it was functioning quite well. They had, there was enough room, and people, it was more than adequate enough. So the house was already built, some folks would say. And in addition to that, why not let people build their own house instead of somebody else building it for you, and then taking some some comments here and there. So I would say, yeah, the house was already here, and let the First Nations, if there's any modifications that need to be made, then let them make it. So here we have, so speaking strictly for Swan River First Nation and not the other sovereign nations of Treaty 8, here is Swan River's traditional territory as of signing on June 21st, 1899, the Treaty 8 boundary. So I've had, what's interesting here is I've had proponents submit plans to Swan River through Alberta's consultation process, and even the maps titled Swan River Traditional Territory, and it would highlight parts of their GDP, for example. And I think, there's a few issues there. Is that proponents don't necessarily take the time to do any homework on the nation, and then this thought that the traditional territory is defined by Alberta's consultation boundary. It's has nothing to do with it. And so, and even that process, I could talk for a whole day on, and the frustrations about it. But here's Swan River's traditional territory. And I mean, at times I feel like sending maps back to the proponents with their plans and their dispositions, and how small it would actually look compared to Swan River's traditional territory. But I think this is, I mean, the Swan River was an original signatory to the treaty, and the current chief, Gerald Giroux, is a direct descendant from Felix Giroux of the signing. So, the nation, demands respect that way. It's more than this consultation policy defined by the Alberta government. So in regards to the history, and I won't get into a whole lot of the detail of the longer history of the nation, just some of the things that I've learned to appreciate and been educated on in the last few years, because I've been working here in the consultation department for 4 years. Swan River, the people of Swan River are proud, and they value their culture, the land, the community, and the connection to the land. So every nation is a little bit different, right? They're autonomous. But Swan River has always held, from my experience, this high value of the land with their culture, lifestyle, livelihood, and not necessarily chasing economic development. And so sometimes there's risks when you're in a capitalist market, you think like a capitalist. And so with Swan River, the focus is treaty rights and culture and livelihood, being able to have a land base that supports those things. And they would never get into an arrangement that would compromise any of that. So those are highest priorities. Now, every nation is different, and that's challenging for sure. So I have I've worked in the forest industry for 25 years, and then the last 4 has been with Swan River. And every day I just come here, it's an honor and a privilege to be hired by the nation to do consultation. I think as a forester and the RPF in BC and Alberta, I've become a better forester, actually. I mean, some would argue I was never any good anyways. I mean, there's a friend of mine, Fabian Gray from Whitefish, just always called me a mediocre forester. So that's probably, most accurate. But I think the view has changed. So coming from a Western science perspective, and certainly learn, that's highly valuable. But I feel working for the First Nation for 4 years now, I view the forest through a different lens for certain, and I think it's only expanded it, and helping on another higher understanding or perspective, I guess. I guess what I really have learned is I don't know very much. And I would say a lot of us don't. And I mean, from Western science, they call subject matter experts. That's in Swan River, folks there's no subject matter experts. There's knowledge keepers that understand certain things, but they would never call themselves an expert. They feel they have an understanding and always a willingness and openness to learn, for sure. I have and then being immersed into the community on a day-to-day basis, just seeing being part of we hold sweats every 2 weeks, and even that, highly valuable. It's a connection. So when they get super hot, it's intense, and you have to find, like, I would encourage most, if you ever have an opportunity, is to go in a sweat. We ended up holding one last year with an invited force companies, and it was fairly well attended. It's still COVID, so some organizations, just internal policy prevented them from attending, but we will be holding more. And I thought it was quite useful, and in a sweat, I mean, you give thanks, right? And so many times, and you pray, and so Swan River members are giving thanks for what they have, which isn't very much. Okay, probably a lot less than most on the call today, but they give thanks for everything that they have, and then they pray for their friends and families and for the people in the province and the world, and they pray for Mother Earth all the time. And that's not something, I mean, I've never been in a corporate conference room and people are talking and they're praying for the land, right? I mean, it's about your operations, and fair enough, right? Because that's a different connection. It's an economic, it's running a business. With Swan River, you have people, like, they're praying for the health of the landscape. So and you don't have to really understand it. It would be nice, right, if more people do and take opportunities to come to culture camps and sweats and stuff like that, so you have a better appreciation. But you really don't have to understand, but you have to respect those things. And respect, there's a different view on the land, and there's different uses on the land. I think a little bit on the sovereignty and self-determination. I think more and more of Treaty 8 First Nations, for Swan River for certain, are reasserting their sovereignty and really defining the self-determination. Like Kate had mentioned, I mean, there was laws in the First Nations people had their own. It was functioning quite well prior to settlement. So just for Swan River, then we just, there's different ways and means of reasserting this sovereignty, and one of them is with our consultation policy. So recognizing, other forms of government have their policies. Well, Swan River, as a sovereign nation, have their own consultation policy, and it's posted on the community website for all to see, and it's not top secret. But that is the expectation that then when companies come, proponents have a proposed project, that they honor and respect Swan River's consultation policy. If follow other policies by all means, but the expectation is that you will be following Swan Rivers. And we are also seeking, co-management type arrangements. Just some other governments, I mean, DFO has reached out a few times. So other co-management is something that's been on the table for a while, different levels of government, but seeking opportunities there for sure. Land use management, I mean, Swan River will, it's actually in the process of doing their own land use type management plan. So again, other governments can define their plans, but the best for Swan River to look after Swan River members, we need to do our own plan. And so, and then you would be able to compare how does this plan overlap with that plan. So another initiative is our environmental monitoring. So having more members out on the land. So as we work through and start developing policies, our own ground rules and those types of things, employing monitors to go out on the land. So if the government of Alberta, agriculture and forestry, or whatever it's renamed now or whatever, and have the FOMP inspections and stuff like that. Swan River will have their own, right? And and out there on and monitor and report. I mean, they've talked about having our own fleet of vehicles with lights, right? And you're driving around, because Swan River, the only folks that are going to ensure that the land is looked after and maintained and the treaty rights protected, the best folks to do that is Swan River. So, and taking steps to make sure going on those lines that it happens. We have a bunch of research projects. We have a 3-year wildlife monitoring program that was similar to the Whitefish Lake First Nation, where they deployed 100 cameras. We'll do another 100 cameras. And so Whitefish did their project in the Boreal Mixed Woods. Swan River will have our program is in the lower and upper foothills, but a similar project design. So hopefully creating a regional data set to be able to do some like a regional analysis. We're going to do some work on aquatic habitats and riparian areas with traditional plants and toxicity and the potential impacts disturbance have. So a suite of disturbances that look at a list, like a smaller list, a subset of traditional plants, the toxicity, but also the potency for the medicinal values. So that one, so when you look at, it'd be one thing to say, oh, here's a disturbance and plants grow back, and okay, but what grows back in these areas, and what is the impact on that, the medicinal value of it. So that, pretty excited about that one. We've done some under the First Nations Environmental Contaminants Program. We've done some fish tissue sampling in the lake. The fish are at the labs right now getting tested. So eagerly awaiting that. We've done community flood mapping, acquired LIDAR, and some hydrologists out of Lethbridge, and so we have some flood mapping. So with the community, helping in any infrastructure maintenance or development, those will be handy. We've done grayling habitat survey work in the Swan River. And then we've done we've done environmental DNA work for Arctic grayling and Athabasca rainbow trout in a couple locations. Swan River has done a lot of work in the Swan River watershed. Mainly, it's been highly fragmented, developed with oil and gas and forestry. And Swan River members actually lost the right to fish grayling. So, a treaty right that they don't have there anymore. And there's a long story behind that one, and a long story of inaction, and which eventually resulted in the loss of a treaty right. And Swan River just said, hey, we can't rely on other people, and we can go to court, and we still can't fish, or we're going to do some things differently so we can get members back out fishing. So been working with a lot of folks, ended up with their own money, had hired a consultant to analyze some work that was done on the crossing inventories, and did some prioritization, and then started reaching out to the owners of these crossings, and that's been highly successful. And it, now we have a Swan River watershed initiative, and it's part of gathering lots of momentum, and it overlaps with this area-based closure program that we're working with some oil and gas companies. So lots of great work there. But I mean, that it ended up with Swan River having to take, ended up losing the treaty right to end up starting moving some of these things forward. I think I'll get, so forest planning, as a mediocre forester, I guess. I mean, this was a big one. There's forestry has a huge footprint and taking up of land, and we have some current case law now that does have, has recognized a methodology that will allow nations to be able to quantify that with coming out of Blueberry, where you can, even as an GIS exercise, throwing for like a 250 to 500 meter buffer on the disturbance. So, and that's been recognized, that methodology. So we can clearly show the footprint that forestry has on the land. And I think that's useful when you start, when whether it's the government of Alberta or forest companies, and you come talking about, and it's through consultation. Actually, I should back up, because consultation, and I just heard this at a Treaty 8 meeting yesterday, it seems, so consultation seemed to be like the only avenue or vehicle that First Nations had to engage and with the government or proponents. And I mean, and it seems to funnel First Nations ability really to comment and provide any input into, funneled through another government's defined consultation policy. And so stepping back from that, and so Swan River has their own consultation policy, but there's other vehicles now that First Nations are using, knowing that, like the Alberta government's consultation policy isn't a meaningful process for First Nations for the most part, or not for Swan River for certain, and actually meaningful I was at a meeting in Edmonton prior to COVID. There was a Supreme Court judge there who had made an interesting comment on consultation, and to be meaningful for that process, or for consultation to be meaningful, the possibility of the project not proceeding has to be an option. So, I think just think about that for a little bit, because who's coming when you come to a First Nation? Who's coming to consult thinking that this may not proceed? In the past, it's been dropping off some donuts and some handshakes and take some notes, and it's a checkbox and adequacy, and away you go. So that's changed recently. Still, again, a long ways to go, but we had this, and this just happened prior to Christmas. We had a proponent come to Swan River starting initial consultation, and they had ended up hiring a third party, to do their consultation for them, and it wasn't going anywhere. It was a frustrating process, and they hired some biologists, and they had their subject matter experts and their HR or whoever they had to check some boxes. Swan River had huge concerns. Next thing you know, we're having a meeting with the executives of this company. They had no idea what was, this consultant who was doing the consulting for them, or consultation rather. So they were kind of disappointed in that. We asked them, is there a possibility that the project won't proceed? And they couldn't answer, obviously, that day, but they got back shortly after, and they said that it was having heard all of the concerns from Swan River, that they were considering it. That I've never heard that before. It's so that feels, it kind of aligns a little bit going down the consent road, but that's something. So you're working with a proponent, and maybe it's smoke and mirrors, I don't know, but it seemed genuine at first that they're contemplating this project now. So that for us meant, hey, that's meaningful consultation. Not that you're shutting everything down, but somebody came here, they heard the concerns, and they possibly won't proceed. And then you can start, okay, how do we start to mitigate or accommodate? So that was interesting for sure. But that was once in 4 years. And so what I find too is a lot of folks throw out, I threw on the slide here words like balance, sustainability, compatibility, integrated, healthy. What did I heard this morning? Respectful and collaborative. So those, we, from Swan River's perspective, I hear those words all the time from proponents. But Swan River isn't saying that if a plan comes in and you work through it, that it's not balanced, it's imbalanced. And sustainability, is that fiber sustainability? It's certainly, for Swan River, it's not cultural sustainability. Compatibility, there's certain land practices that may be more compatible with, say, some of the traditional uses than others, but we have to have lengthy conversations about what that looks like. And integration means we're integrating these different perspectives and land uses on the land, not just integrated, here we consulted with you, we took some notes, we heard a couple things, and now, we protected a berry patch and a moose lick or something, and you're site specific, like came up this morning. that's Swan River doesn't see that as integration and healthy. I mean, there's different perspectives on what you see as a healthy forest, and I wouldn't say one overrides another. They're equal, and if we're coming at these things with a process that's inclusive, we can do all of these things better. But right now, a lot of it from Swan River's perspective is one-sided. And so government of Alberta and industry in general have, benefited quite well from the exploitation of the resources and the vast resources in Treaty 8. And so that have led to like the loss of land use, alienation for Swan River First Nation members on the land. So we need to rejig these things. And the system, at a conference recently, we were talking about systemic racism and in the forms of policy. So some of these things, it makes it very difficult for a First Nation, and Kate touched on it as well in the capacity. And just, I think we are at a spot where we can change a lot of these things if folks are coming to the table with an open mind and not as educational. Here's some plans. We're following the consultation, Alberta's consultation policy review. Give us your site-specific concerns. We need to really step back, and I feel like the forestry companies that Swan River deals with right now have been fairly open, and we've made some progress. And I'll go through some of those things.
Hey, Todd, I don't want to interrupt you. Just giving you the heads up. You got about 10, 12 minutes just so we can get questions at the end. No worries.
Yeah, well, that was my fear when I was.
No worries. Yeah, I'm giving you 10 minutes.
So I'm either not saying anything or I just go too hog wild and then can't stop. So here's quickly then, well, whatever that means. So I thought that with forest management plans, and I think for Swan River, we would see the biggest bang for our buck. Well, maybe that's not worded properly, but where the most opportunity is would be at more of a landscape level forest management plan scale to be able to address a lot of the issues and concerns and possible mitigations, and not kick down the road to more of the operational plans. I mean, what's interesting, through a recent forest management plan, we were bringing up concerns about moose and moose habitat, and there was the local biologist had left. He wasn't on the PDT anymore. And then when Swan River kept raising the concerns on moose, the reply was, there's no biologist, so it's best to deal with that issue in operational plans. And I mean, I don't know how that wasn't meaningful at all. We wanted to continue the conversation, and then it got kicked down the road to operational plans, which puts a huge strain on nations because you're dealing with so many other things on an annual basis. And Swan River doesn't take any capacity funds from Alberta. It's just self-funded with arrangements we make through the forest companies and oil and gas. So quickly for Voights, I mean, a big part of a forest management plan, we've gone through a couple here now, and companies come out and they say they're consulting on their Voights table. Here's what are your issues, concerns. I did a compare and contrast on what was initially of compare and contrast documents, and so what was initially submitted and what was in the final submission, and 5 or 6 words had changed, and that was like ands and its or something like that. So nothing really in the content. I have a 1,300 page rock log though. So I think for Voights, we really wanted to get into there where there's opportunities in different harvest systems. I think Chris had even mentioned this morning the checkerboard, which maybe that's an okay option in some areas. I think, like as foresters, we know there's lots of options out there, but it's which ones facilitate with the uses for, say, Swan River members, where there is some compatibility on certain land uses, and how we manage that over the landscape. Water was an interesting one. We had concerns about that, water and water quality and quantity. Was in the voids table. No, we had concerns. Nothing really came out of that. There's a ECA model for quantity, and quality is covered by legislation, operating ground rules, which I would ask anybody here. I tried to get the science behind the current OGRs, like on the 30-60 meter, where that came from and the science that supports that. I think back in the early 1990s it was developed, and I'm not aware of anything really happening to amend any of that stuff. We veg management, I mean, we could get into a big conversation on herbicide, huge issue. I mean, how much time do I have left?
8 minutes, buddy.
Huh?
About 8 minutes. Okay.
Veg, I got to give this example for veg management. We got a proposal in, and got back. So got back to the folks who were doing the consultation on this, and it had said there's a cultural site, there's medicines that are important, there's a youth hunting camp there. I think there was also an elders, highly important area. Got right out of the gate, I get a bunch of science paper, some papers saying how safe glyphosate is or whatever. I mean, you don't start consultation off like that. But anyways, not meaningful consultation. Anyways, meaningful for the First Nation. Said there was concerns. Said members don't go back to this particular area when, like, they don't go back when areas are sprayed. The folks doing the consultation actually went out to the field. Didn't invite Swan River members to go out. Comes back and says, "Oh no, you're wrong. Plants grow back." And we had never said plants don't grow back. I mean, I was in the industry for a while. I know it grows back. Just I was saying that Swan River members won't use it. Anyways, we go back and forth. They make a couple smaller mitigations. We were asking not to spray that area. I'm sure, and it was not even very large. I don't even know if it was a couple hundred hectares or whatever in the grand scheme of things. So anyways, we go back and forth with the regulator, and then lo and behold, because we were expressing the concerns, and said, well, Swan River didn't identify if it was rare or endangered. And I didn't even know that was part of a consultation. So now the plants had to be rare and endangered. I thought we clearly articulated what the concern was, the use, and didn't provide any alternative areas. And that's happened a few times now, where we say, okay, these are the uses. If you can't, if these need to be sprayed, give us areas that you won't spray. And so that's been a challenge. I think I won't say any more there. We've made progress. On a birch strategy where the companies around Slave Lake have agreed not to harvest birch larger than 16 inches. I believe it's 16 inches. So that's been a big plus. Structure retention, I mean, I could go on for hours on this one, but we have a working group now that's been kicked down to, like, we wanted a conversation on the management plan, but it's got kicked out of there. But we have a working group now. We are having, we're doing site visits with our knowledge keepers and land users from Swan River to say, okay, going out, looking at the goods and bads. And we are going to have a workshop here to redefine maybe what structure retention looks like in some key areas for the nation. Herbicide, we had some success with companies committing, say, not spraying certain blocks. We would like to have it. We wanted to have the conversation at the management plan where they could block out whole compartments. That didn't go anywhere, where it's just blocks at this point. Buffers, we've had success. We're in the Swan River watershed where the companies have committed to a 200-meter buffer on the Swan River and 100-meter on its tributaries. So we're quite pleased with that. And and I'm starting to have members come in that are out on the land saying things are starting to look a little different, and that's what we want. And actually, there was a First Nation void in the latest management plan here, and we still have to work through what the performance measures will look like, and a lot of that will be with Swan River reaching out to its members to say, here, if these changes in land practices will facilitate more use, and how you can quantify that. So we'll start like surveying the people and saying, hey, has this particular activity increased X percent over the last few years, and tie that back into some things that we've been doing different on the land. So that's still a work in progress. And I think we have a fairly comprehensive consultation process, and hats off for the companies that we've been dealing with so far that have really, they've stepped up. We're working together on these things. They've through our consultation process, our site visits are fairly thorough, and still, again, working through what that looks like. We collect the information. It's a fairly detailed process, and we circle back. There's monitoring involved in it, and going back and forth on mitigation. So I feel positive about that. There's still a ton of work to do, and it's been, like, as a forester, this job has been the most frustrating. I think it's super challenging, but it's been pretty frustrating dealing with through some of these other policies and stuff, and governments and industry who just, where it doesn't necessarily, it's not that meaningful, and it's just it's tough when you're trying to battle and look after people's, they have rights on the land, and at this point it's not really much balancing. So, but we have been making progress. So anyways, I'll be quiet right now. Thank you all.
Oops, let's turn my camera back on. First one, I'll let Todd or Kate kind of decide, although one's for Kate. This one here is to this point, capacity funding is primarily provided by industry. Do you think the federal, provincial government should also provide this as well, considering its legal responsibility for consultation?
Thanks. I can take a shot at that, and then Todd, I'll check in with you if you've got anything else maybe to add. I think it's an important question, and one that comes up quite a lot. I think ultimately there's no easy answer, because as Todd has alluded to, there are certainly circumstances where First Nations are able to get through consultation without relying on government funding. But I would say that because consultation originates, the proponent wants a project to proceed, and the government has the duty to consult. And so one way or another, it's really important that First Nations have the resources to participate in that process, no matter where it comes from. Both of the other parties have reasons that really support making sure that happens. And so I think it's what I see very often is it falling through the cracks where government doesn't provide the funding, industry doesn't provide the funding, and the First Nation is left struggling to try to provide input into a consultation process without having the resources to properly participate. So I guess in a nutshell, no matter which entity does it, it's critical, and given the end of the day that is responsible, I think it also, whether they're providing the money directly or whether they're directing proponents to do it, I think there's a real clear obligation there to make sure that First Nations can meaningfully participate. Todd, do you want to add to that at all?
Yeah, I don't really have much to add to that, Kate.
Okay. Next question then. You mentioned that Swan River had developed their own consultation guidelines / requirements. Wondering which groups, communities, stakeholders were included in that process.
So the First Nations they develop their own as a sovereign nation, their own governance, right? With Swan River, though, like in terms of consultation, so they're different by community, but we have regular meetings. So the nations communicate amongst other nations. So we have working groups, and this stuff is just I wouldn't say it's consulted, but we're sharing the information. So it wouldn't be like with stakeholders, but it is with other First Nations that we share this information. And we have like these protocol agreements for example, for Swan River, when we share information with other nations on things like this. Did that answer the question? We share with other First Nations.
Okay. Kate, next one's for you. As individual members have treaty rights, is it reasonable for the Crown / proponents to withhold direct consultation with members who want to engage on mitigating risk to rights?
Yeah, so I think, just trying to make sure I understand the question. I think it's a question on whether the Crown or proponents should or should not consult with individuals as opposed to the larger collective as a whole. And yes, sometimes conceptually it can be a bit complicated because the treaty rights are held by the collective, but of course individuals can exercise the rights. And so while I don't think there's necessarily something wrong per se with a company or government engaging with the individual who has a concern, when we're talking about fulfilling the duty to consult and upholding the treaty relationship, that's not a say proponent or Crown individual process. That's a government to government, nation to nation, or in some cases delegated in part to companies process that takes place with the nation or the rights holding group as a whole. Hopefully that addresses it.
Okay. Next question. Given all the concerns with consultation, expectation differences, and the timelines of a forest harvest operation, isn't there an inherent incompatibility?
Todd, do you want to start with that one?
It's probably more geared towards Todd.
Well, there is, I think, to a certain degree, like currently anyways, it's how we work through where there's where it could be compatible, or where there would be like exclusion area, I guess. I think I have, like, I wouldn't mind, I'd like to read this, came out of a meeting yesterday, where First Nation rights include a right to preserve and transmit culture and customs, including language, beliefs, ceremony, and livelihood, to children, grandchildren, and future generations. This is a relational approach to being, and seems incompatible with like government and industry thinking. Now, so, but I think, like, so from on the grounds type, and maybe as a practical forester type, there would be, and this is stuff that keeps me up at night, is where there would be what operations that are in the toolbox for, say, forest companies that would be compatible with land uses for Swan River First Nation members. And it's getting, and so it's changing some of those harvesting practices, some of the silviculture practices, maybe some of those timelines, and getting people back out and saying, hey, this is, I think we even had ideas about changing up rotation length in certain compartments. So if you provided an area that people could go, you know, with, I've seen quiet enjoyment came up earlier somewhere today. And just if the community knew there was areas to go that they weren't going to be developments for the X amount of years, you could go and set up camps, do your thing, and move around on the land, where there's going to be some conflicts that may exclude some uses, and then others where we just, you know, the members want to go without any development, because it seems like it's never really one and done. So you have a spatial harvest sequence and you think, okay, you're gonna log a compartment, and with the idea of, you know, fire, say, with the pattern. But there's some areas where you're going in for 10 or 15 years. That's one company. And then you have 2 or 3 other companies that are still opening up roads, going in. And so there's like Swan River members don't like to go where there's activity. So you have multiple companies, and it's forestry, oil and gas, are going into areas year after year after year after year. So in some of those cases, it's not compatible. And what things can we do to, there's so many tools that we could look at. And yes, there could be impacts to AAC, and maybe not, but we need to sit down and look and say, okay, here's what the options and here's what they look like. Like right now, we know that business as usual for Swan River, it's not compatible. So folks aren't out there on the land like they used to be. So we need to sit down and say, okay, what, you know, really balance then from different perspectives of balance.
Okay. All right. We got a last question here. Looks like it's for Kate. I've heard multiple interpretations of land ownership resulting from treaty agreements. One being that a treaty implies land is ceded to the Crown, and another being that ceding land was not the intent of the treaty, rather sharing of land and protection of rights. Can you provide some clarity and or your interpretation on this?
I'll try. Yeah. So
it's an easy question.
Yeah, it's a good one to end with, I think. Though. So I guess it's not so much my interpretation, but just I think it's been repeatedly and really unequivocally stated by the Indigenous signatories to the treaty that it wasn't a treaty about ceding land, but rather about sharing of land and protection of rights. And that's based on oral understandings, histories, experiences, and cultural understandings that have been passed down through generations. And there's also a lot of historical and academic work on this that's beyond the scope of this presentation, but that I'm happy to point folks in the direction to separately. But what I think might be important for us, just in terms of looking for a way forward, is that whether there's a difference perspective or not, for the past 100+ years, events in Treaty 8 have largely proceeded based on the assumption that the first perspective, the ceded one, is correct, despite the fact that all of the Indigenous parties to that treaty don't agree with that. And so I think it's really incumbent on us to try to find a way that actually makes space for that other viewpoint, especially given what's happened in the last 100 or so years. And then lastly, just that I think it's also important not to conflate always concepts of ownership of land and jurisdiction, and that those are both important questions. And so regardless, I think, of the status of the land now, there is also important questions that remain about who has the right to make decisions about them. And that's also an important part of how we kind of reconcile and find a way forward based on different perspectives.
Perfect. Thanks, Kate. Okay, I'm not seeing any more questions, and we're pretty much at time here anyways, about 3 minutes and change. So yeah, let's take this opportunity, I guess, to thank Kate and Todd for presenting today. Like I say, very interesting, very varied perspectives. Glad you guys came, and yeah, I'm looking forward to hearing more from you guys as time goes on here. What we will do now is I'll bid Todd and Kate farewell here from the stage. We'll take a small break. I'll stop presenting here, and then we will start up again at 2:45 for the last presentation. All right. Thanks again, guys, and we'll see everyone here in about 15 minutes or so.